Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate. In today's class, I will discuss about section 413 of BNSS. Are you having any idea about the said protocol? If you are not having any idea, then the present class is important. Please have a notebook with pen or pencil so that you could maintain your information in recorded format. Now, directly I am coming on the protocol. Section 413 of BNSS is inter alia part and parcel of chapter number 31 of BNSS. BNSS means Bharatiya Nagarik Suraksha Sanhita. The said chapter inter alia deals with the protocol of appeals. Apart from that, section 413 of BNSS correspond to section 372 of CRPC 1973. As we know that by the virtue of section 531 of BNSS, CRPC has been repealed. So in that scenario, we have to rely on section 413 of BNSS while preferring an appeal. Now directly I am coming on the point. Section 413 of BNSS is having two applications. Number one, the general application. Number two, the specific application. As far as the general application is concerned, it says that no appeal shall lie from any judgment or order of a criminal court except as otherwise provided by BNSS or by any other law for the time being in force. So simply we could say that the appeal will not lie from the judgment or order of a criminal court. To make an appeal, there must be protocol or provision in BNSS or any other law for the time being in force. So if there is no such protocol, in that scenario, the appeal could not be preferred. So simply we could say that we are not having the fundamental right to make an appeal. If we want to make an appeal, there must be provision in the statutory provision, which is BNSS or any other law for the time being in force. For example, you are contesting a case as per the Protocol of Protection of Women from Domestic Violence Act. Inter alia, there is an order against you. You want to make an appeal. For this, you have to rely on section 29 of that legislation. For this, we are totally covered by second part of section 413 of BNSS that says that the appeal shall lie from the order of a criminal court as per the protocol given in any other law for the time being in force. So basically inbuilt protocol is given in the Domestic Violence Act. So in that scenario, the right to appeal would prevail. Apart from that, if any order is passed by the magistrate or a court of session, and if the specific protocols are given in BNSS, which inter alia gives you a right to make an appeal, in that scenario, the appeal could be preferred. I want to clarify that the proviso attached with section 413 of BNSS is having the specific application. It inter alia gives right to victim to prefer an appeal. But the key point is that we are having multiple scenarios in which the victim could prefer an appeal. Number one, against any order passed by the criminal court acquitting the accused. So the first circumstance inter alia indicate the case of acquitting. In case the accused is acquitted, the victim is having the right to prefer an appeal against the order of acquittal. Point number two, the victim shall have a right to prefer an appeal against any order passed by the criminal court convicting the accused for a lesser offence. So inter alia, if the accused is charged with multiple offences and he is acquitted from all the offences except for the lesser offence, in that scenario the victim is having a right to make an appeal. So for this we have to rely on category number 2, that is convicting for a lesser offence. And the last category is that imposing inadequate compensation. For this, we have to refer the cases of negotiable instrument act in case the compensation is inclined, but it is on lesser side or it is inadequate. In that scenario, the complainant could prefer an appeal as per the protocol of section 413 of BNSS. Please be noted, there is no protocol of appeal in NI Act, so the concerned person has to rely on section 413 of BNSS. But the key point is that while moving on the specific provision that is attached with section 413 of BNSS, only victim is having the right. Please be noted, accused is not the victim. So if you are the victim, means you have suffered a loss by the act of accused. So you may prefer an appeal, but under the following three categories. I'm going to repeat. Number one, against the order of acquittal. Number two, against the order convicting the accused for a lesser offense. Number three, against the order by the virtue of which the compensation is imposed, but it is inadequate. Now the key point arises, to which court the appeal would lie. For this, we have to prefer the last part of section 413 of BNSS that says such appeal shall lie. Again, we are having the word shall. Shall means imperative. Such appeal shall lie to the court to which an appeal in routine lies against the order of conviction of such court. For example, you are convicted by the trial court, means the court of judicial magistrate. In that scenario, if it is a complaint case, previously we have to move before the Honorable High Court as per the protocol of section 378 subclause 4 of CRPC, but now the said protocol has changed the mystery. Now the victim could prefer an appeal before court of session, because from the order of conviction or acquittal passed by the concerned trial court, that is the court of judicial magistrate, the appeal lies to court of session. And apart from that, we are having multiple judgment from Honorable Punjab and Haryana High Court, Honorable Chhattisgarh High Court, wherein it is specified that in a check case, if the accused is acquitted, in that scenario, there is no need for the victim, means complainant, to prefer an appeal before Honorable High Court for seeking leave. He may prefer an appeal before court of session. So simply we could say that the said section inter alia provides us two important rights. Number one, we could make an appeal if inter alia protocols are given in the special law. If not given, inter alia the case is covered by the protocol of BNSS, the appeal would lie. Number two, the victim could prefer an appeal in three cases: against order of acquittal, against order of conviction convicting the accused for lesser offense, and apart from that, the compensation is inclined or awarded, but it is on lesser side or inadequate. In that scenario, the appeal would lie. So I think that I am totally able to enlighten all of you about section 413 of BNSS. If you are having any query, please feel free to put your question in the comment box so that I could answer them as per my knowledge and capabilities. See you in the next video. Till then, Jai Hind, Jai Bharat.